The letter said my home was scheduled for foreclosure. Not a warning, not a fine, a foreclosure notice. According to the HOA president, unpaid violations had reached a point where the association was now moving forward with legal action. There was a date. There was a reference number. There was language that made it sound final. I read it 3 times before it felt real, because foreclosure isn't a debate. It's a countdown. But when I started digging into how it had been filed, one thing became clear. She wasn't supposed to be able to do this at all. And that tiny gap between what she claimed and what she actually had authority to do, that's where everything unraveled. The violations hadn't seemed catastrophic at first. A few fines, a couple of disputed notices, the kind of back and forth that happens in most HOA neighborhoods. I'd challenged some of them, paid others I thought were minor just to avoid endless emails. Nothing felt even remotely close to foreclosure territory. There had been no court hearing, no formal judgment, no payment plan discussions, just routine enforcement letters. So when the foreclosure notice arrived, it didn't match the history. I pulled out every document I had, every notice, every ledger statement, every email. The balance listed in the foreclosure letter didn't align with anything in my records. It was inflated, rounded up, stacked with legal preparation fees I'd never been notified about. And that's what made it feel different. This wasn't just about collecting unpaid fines. It was about leverage. When I asked the HOA president for clarification, the reply was short and deliberate. The association had the authority to enforce liens and pursue foreclosure under the governing documents. Payment was due in full. The timeline would not be extended. But something about the wording bothered me. It cited authority, but didn't cite the exact section. It referenced legal action, but didn't mention a court. And foreclosure isn't something an HOA president simply declares. There are steps, requirements, safeguards. I started reading the bylaws again. Then I checked state law. And that's when I noticed the first crack in what looked like a solid threat. Because while HOAs can place liens in certain situations, foreclosure is an entirely different level of power. And that power doesn't belong to just anyone on the board. The more I researched, the less the notice made sense. Yes, HOAs can place lien for unpaid assessments. That much is common knowledge. But foreclosure isn't automatic. It requires a series of very specific steps. Proper notice, opportunity to cure the debt, board approval under documented procedure, and in most states, a court-supervised process. None of that had happened. There had been no hearing, no certified demand for payment, no vote recorded in meeting minutes approving foreclosure action, just a letter. And the letter looked official enough to scare someone into paying immediately. I requested a full account ledger from the HOA. The numbers shifted slightly in the updated version. Some fees were labeled differently. New administrative costs appeared. It felt less like accounting and more like pressure. Then I requested something more specific. I asked for documentation authorizing the foreclosure filing, a board vote, a resolution, any formal record. The response was evasive. The HOA president stated that the board had discussed enforcement options and that the association's attorney had been consulted, but there was no attachment, no meeting minutes, no written resolution authorizing foreclosure. That's when the timeline started to matter. Under state law, foreclosure proceedings can't even begin unless certain financial thresholds are met. The unpaid balance must exceed a specific amount. In some jurisdictions, a minimum number of days must pass after written notice before action can be taken. My balance, after removing the questionable fees, didn't meet the threshold, not even close. Which meant one of two things was happening. Either the association had miscalculated, or someone had intentionally escalated beyond what was legally permitted. I contacted the county clerk's office to verify whether any official foreclosure filing had been entered into record. There wasn't one. That changed the entire tone. The letter had referenced a case number, but there was no case. It mentioned scheduled action, but no court date existed. It was structured like a formal foreclosure notice without being tied to an actual filing. That's when the fear turned into clarity. Because threatening foreclosure and actually initiating foreclosure are two very different things. And if the board had skipped the legal prerequisites, the notice wasn't just aggressive. It was premature, maybe even improper. Meanwhile, the HOA president continued sending reminders that the deadline was approaching. The language grew sharper. The urgency increased. She warned that failure to comply could result in irreversible consequences. But the more pressure she applied, the clearer the gap became. There was no court, no filing, no lawful authority to move forward yet. And if that tiny procedural requirement hadn't been satisfied, then the entire foreclosure threat rested on something fragile, something she hoped I wouldn't check. But I had. I stopped responding to the deadline emails. Instead, I sent one formal demand. In it, I cited the exact state statute governing HOA foreclosures. I referenced the financial threshold requirement. I cited the mandatory pre-foreclosure notice provisions. And I requested written proof that those conditions had been satisfied. Then I did something else. I copied the association's attorney, not to threaten, not to argue, just to clarify. Within 48 hours, the tone shifted. The attorney responded, not the HOA president. He requested clarification regarding the balance calculation. He asked for time to review the ledger. He did not mention a court date. He did not confirm that foreclosure had been properly authorized. That silence said everything. Because if foreclosure had truly been initiated, there would have been a case number on file, a docket entry, a formal complaint, something traceable. There wasn't. And when the attorney reviewed the balance, the math changed. Certain legal preparation fees were removed. Administrative add-ons disappeared. The total dropped below the state statutory threshold required to even begin foreclosure proceedings, which meant the original notice had been sent before the association had the legal right to send it. The next communication came quietly. The foreclosure notice was being withdrawn pending review. No admission, no apology, just a soft reversal of something that had been framed as final. But the most telling moment came at the next HOA meeting. When asked about the foreclosure letter, the president referred to it as a preliminary enforcement communication. Not a filing, not an action, just communication. Yet the letter had used the word foreclosure repeatedly. That word wasn't accidental. It was leverage. And once the legal requirements were exposed, that leverage evaporated. Because foreclosure isn't something you imply. It's something you earn the authority to pursue. And she hadn't. After the notice was withdrawn, everything became noticeably quieter. The urgent email stopped. The countdown language disappeared. The balance was recalculated properly, and several questionable charges were permanently removed. What had been framed as an unstoppable foreclosure suddenly became a routine account review. The association never admitted the mistake. They didn't have to, because the next time enforcement was mentioned, the tone was careful, procedural, precise. Every step cited properly. Every reference linked to the correct section of the bylaws. The fear that followed that first letter lingered for a while. It's hard to unfeel something like foreclosure. Even when you know it wasn't valid, the word stays heavy. But the bigger lesson wasn't about fear. It was about process. HOAs can enforce liens. They can pursue collections. They can even foreclose under the right circumstances, but only when every legal requirement is satisfied. Skipping a step doesn't make enforcement faster. It makes it fragile. And the moment someone checks the statute instead of the tone of the letter, that fragility becomes obvious. The house never left my name. The foreclosure never moved past paper. And the next time a notice arrived, it looked very different. Because this time, they knew someone was reading more than just a headline.